So I think I will go ahead and start because we are running a tight schedule today. Welcome everybody. My name is Krista Nadekava-Karin, and I am welcoming you from the side of the Swiss Institute of Comparative Law in Lausanne, Switzerland, to our conference on adult protection that we are co-organizing with the FL-EUR and the University of Geneva. The Swiss Institute is a federal entity, and we have a legal mandate of providing information about foreign, that is non-Swiss law, as well as international law. And providing information about legal developments around the world guarantees that much of our work addresses the most topical questions facing legislatures, lawyers, and the general population. And our interest in current debates is only surpassed by our interest in how the current debates differ from jurisdiction to jurisdiction, or, as in the case of today's discussion, from legal perspective to legal perspective. And the topic of today's conference, adult protection, fits these interests perfectly. It's current. I was looking at some law review articles, and in 1996, which for many of us doesn't seem that long ago, a law review article author was writing that guardianship is among the least noticed, least discussed institutions in the working legal system. And today, the public attention to the status of adults with mental ill health or mental disabilities preoccupies not only legislatures and parliaments, but also the wider public. And of course, we've all heard about Britney Spears. Now, the question of legal regulations on adult protection also differ across jurisdictions. Again, an area of our interest. Anywhere from the grounds on which a person can be judged incapable and the choice and prerogatives of the guardian or the obligations of the supporter, to the degree of involvement of the legal system itself. These are things where we differ depending on our legal cultures. And today's program will also touch on such differences. But our focus in organizing this event really lay in looking at how, across jurisdictions, the values and practices of family law converge or diverge from the values and practices of the law of persons with disabilities. Where protection or best interest oriented treatment was dominant in adult care, calling for substituted decision-making into the late 20th centuries, the values of autonomy and supported decision-making have grown as disabilities law has promoted the idea that every individual has a right to have rights. But does the broad acceptance of supported decision-making in family law mean that the values of family law and those of disabilities law are the same? More provocatively, how much is family law and the values it holds dear still relevant to adult protection? And on the other side, how does the value of autonomy in the law of persons with disabilities work in practice when those offering care and support struggle to discern the will of the intellectually or psychosocially impaired individual? I hope we can have some insights on these questions in the short time we have together. And before I hand over the floor to my co-organizers, I ask you to please be aware that this conference is being recorded and that the recording will be placed on the internet. So your questions or comments might be publicly heard or looked at. Secondly, we are offering closed captions for this conference. We have professionals listening to us and transcribing simultaneously. And they are available to you if you click at the bottom of your screen so that you can see the captions. To help the transcribers make an accurate text, we ask that you speak clearly and loudly. And if you have one, with a microphone, it just helps with the audio quality. And now it is my pleasure to hand over the floor so to speak, to my co-organizer from the Family Law in Europe Academic Network, Masha Antokolskaya.
Thank you very much, Krista. I don't need to introduce myself any longer. I am Professor of Family and Private Law from the Vrije Universiteit Amsterdam, and I'm representing as a chair Family Law in Europe Academic Network. And many of, I think almost all the members of this network are also present. Well, why Family Law in Europe Academic Network, FL-EUR, you can short it up, is interested in this subject. We are co-organizer and initiator of this conference because Family Law in Europe Academic Network has chosen this subject as its first field of interest. Family Law in Europe Academic Network is a non-governmental academic initiative, and it covers 28 European jurisdictions, and everyone is there on their own academic or other professional title. So we're not representing governments or anything, only our own academic interest and involvement. And it goes without saying that when the FL-EUR have chosen this subject as its first field of interest, that's because it's one of the most important subjects that we now have in family law and the law of persons. Actually, we were discussing three subjects. One was high conflict divorce, other was the new issues of parentage and affinity, and this one. And autonomy and protection, empowerment and protection of vulnerable adults has won over the others. It may be because the adults, especially, and also, well, they are our future more than the children. That demographic situation shows this very clearly. We have more adults and, well, unfortunately, less children. And care for adults puts more pressure on our system, not only financially and organizationally, but also challenges us mentally as professionals as well. Because for us, as Krista very nicely pointed it, it was seen as completely normal that the adults with some impairments were treated like minors, or they were just offered support and protection. And then with the adoption and on the way to adoption of CRPD, that started to change. And now we are in a process of change. And this process of change is extremely challenging from the perspective of a comparativist or a legal historian as well. Why? Well, what's special about this? I have written a book on the history of family law in 2 millennia. This subject have not been covered. And what is the problem? If we look at family law, it's very difficult to have any teleological interpretation because we do not agree about what is the final point. We have persons who are more conservative, we can have persons who are more progressive. So in divorce, you can hold that more admissive, more permissive divorce is our target in development, but we also can say it's detrimental for children, for well-being of the adults. So we should try to make divorce less popular, let's say. But here we have a very, very interesting difference. All the jurisdictions we deal with as the FL-EUR, but also in the world, have ratified the CRPD. So they have signed to the final goal. We all know where we want to be. So there is no difference in target. You can easily have this teleological interpretation. So the problem is only how to get there. And what is determining that we are not having the same pace, the same solutions. And from the point of view of comparative law and comparative legal policy, it's very challenging. what determines our choices, our paths, and our tools. We have this notion in comparative law, functional equivalence, so we can have different solutions for the same problem, and we can have, for instance, titles that differ, but in fact we have this to have to deal with the same phenomenon, and this all would be revealed hopefully today in the first process. In the terminology, in other things, are we talking cross purposes? Do we have it about the same things? Well, I've talked enough about that, and my presentation about FL-EUR is this next. I would like to introduce you a little bit to our program. Well, it has slightly been changed, and if we look at that, the first session would be starting with me bothering you a little bit more further with the more explanation about the FL-EUR, and then Professor Markus Schaefer will tell us more about CRPD from the inside perspective. And there will not be a discussion, it's just two introductions. After that, we have a coffee break. We have decided that during the lunches and the coffee breaks, we would open the Zoom so everyone could stay and try to chat. If there will be more interest, maybe we can even make breakout rooms that have not been foreseen so far, but just express your wishes. Then we will have the first section. After that, when we will discuss the core issues of the subject. What is legal capacity? How could it be limited or not? What is own will and preferences as compared to the best interest principle? And what is the proper role of the state as a guardian? After that, we will have an extensive discussion. We have panels, so everyone can take the floor, and to do that, please just use you. I'm probably not, I will share the program with you. Can you see my program now? Yes, I hope so, yes. So this is the first subject, this is the second one, and you can see here that we have links to long presentations. You can look afterwards, and then they are pre-recorded. You can, some of you have probably already listened to them, but they will remain in place. So later on, when you have time, or when, for instance, the FL-EUR members would like to look at them writing their national reports, you can always do that. And then we have a lunch, then we have another session, and this session would also end with discussion, and the rules are the same. So you are very welcome to take part in all this discussion, and I would like you to keep your microphones muted during the presentations. We have also changed the order of presentations in the very last session, but you will also see that, I think, easily. And so you are very welcome, and I hope we will have a very fruitful discussion today. I am passing the floor to the last co-organizer, last but not least, Michel Cotier.
Thank you very much, Masha. So I extend also a very warm welcome from the University of Geneva, which I'm representing here. My name is Michel Cotier. I'm a professor of private law at the Faculty of Law of the University of Geneva, and I'm also the Swiss member of FL-EUR, Family Law in Europe academic network. The Faculty of Law in Geneva has a strong focus on human rights, and is all the more delighted to be co-hosting this conference. And one of the topics has, of course, been recently the rights of persons with disabilities. And as the director of the Center for Legislative Studies, the CETEL, I'm also delighted that FL-EUR has a multidisciplinary approach to the subject of comparative family law and to adult protection in particular. The original idea of choosing this collaboration between the Institute, between FL-EUR and the University of Geneva was not only to link the FL-EUR project to the Institute's comparative law endeavors, but also to make the link to Geneva as the home of the UN human rights treaty bodies, and more specifically to the CRPD convention. So we're a bit sad that we're not able to be physically in Lausanne at the beautiful shores of the Lake Geneva, where actually today the weather is really gorgeous, and I tried to bring it in with my background picture a little bit from Geneva this time. So we hope that the spirit of human rights, which is the spirit of Geneva, and the Lausanne spirit of the Institute will be able to be present somehow in this Zoom meeting. And we're happy that this online format allows for more people to attend. We think that's the big advantage of the Zoom format, that we have a more international conference finally. So I will now change into moderator mode. This is my role for the first session, on which Masha already commented briefly. So the idea of our first session is to introduce us to the two perspectives. Krista commented on the fact that we aim at bringing together the perspective of private law, adult protection as an area of family law, with the rights of persons with disabilities perspective, so the more human rights perspective. This has become an aim of family law in general, and family law in general has been more and more influenced by the human rights perspective and by human rights instruments. And we are very grateful that we're able to discuss this issue with two eminent speakers, or to hear from two eminent speakers in this first session. So we will hear from the perspective of family law, comparative family law, Professor Masha Antokolskaya, who already introduced herself briefly. I will say a little bit more about her to introduce her. And we are very grateful to welcome Professor Markus Schaefer, who will approach the topic from the inside perspective, as has been said earlier, of the committee, the CRPD committee, and he will introduce us to the perspective of disabilities law. So Masha said she doesn't need more introduction, and it's true that for us family law scholars, she is really not, she does not need such, but I like to underline that she really is one of the leading scholars worldwide, and also a very strong initiator of networks. She is the initiator of this Family Law in Europe academic network, this initiative, which is dating back to 2019. And she is also the president of the International Society of Family Law. So she brings together family law scholars worldwide. She's a member of the Academia Europaea, and also a member of the expert group of the Commission on European Family Law, CEFL. She's the editor-in-chief of the journal Family and Law, which is an online open access journal, and also a member of the editorial boards of several other journals. She has authored the comparative historical study she already mentioned on the harmonization of family law in Europe. So she has a very far-reaching knowledge of the long-term developments of family law, which is very valuable for our context. She has authored more than 100 articles and reports in Dutch, English, and Russian. So she's a truly international scholar. She will start introducing us to the work of FL-EUR, and I will give you first the floor, and I will then in a second step introduce Professor Marcus Schaefer. So Masha, you have the floor.
Thank you very much. Well, after such introduction, it always makes me so shy, I could hardly speak. So I will be speaking about FL-EUR. So it has been established in Europe in 2009, in Amsterdam in 2019. And I have already told you actually that it covers 28 jurisdictions. This is the symbol, and this is little flowers who are painted by a young woman who was paralyzed from her from her neck, and she could still learn how to paint in that state of hers, keeping the brush in her mouth. And she made these flowers, and I thought it would be very fitting to put it in the FL-EUR member. Well, what is FL-EUR's targets? Well, FL-EUR wants really to promote academic cooperation in comparative and multidisciplinary way, learn from one another's experience, provide up-to-date comparative data, but its harmonization of family law or private law or law on persons is not its target. So it would be just only taking giving more information, more insights, but not proposing any principles or any rules that could be taken over by others. We see that the subject is quite broad, but no private international law is covered. I think we know enough of private international law to know how complicated it is and how little we know about it, not to be overcourageous and take it on board. And as I already said, the first meeting has chosen this subject, empowerment and protection of vulnerable adults, as its first subject. And well, it has no further comments about the importance of the subject. This is the working method of the FL-EUR. So first, the quick scan have been made at a very measures function and what adult protection measures are in all these. So every member should be able to describe his or her own system using would be made. The deadline is 1st September to set evaluations. We will look at the law you could proceed. You can do this, you can do that. And if you do this, this could be the differences. You should be aware of these possible dangers or pitfalls. And then the governments, the international organization or other professional associations or organizations will be free to use this material as they think fit. This is the time pass. Quick scans have already been done and then they have been published. Then the questionnaire was finalized quite late in June 2021 because the COVID has, well, it was a little bit as of a spoiler. Not only that, it had impact on the persons of coordinating group that was charged with this task of developing the questionnaire, but also it was not thought that it is wise to burden the members of the FL-EUR with trying to complete these reports during this very, very difficult, very hard year and a half that is behind us, hopefully. And this is the first conference where the very first results would be presented, but also this conference from the FL-EUR internal perspective is to provide the reporters with the theoretical feedback. because, as I said, the members of the floor are not necessarily experts in this particular field. It's broad. So they really need this very specialized knowledge, and they are free to work together with their core reporters, and many have already used this possibility, who are truly experts to make these profound reports. So the country reports, they will be expected in September 2022, and then they will be first initially analyzed, and after that an in-depth analysis would take place, and this range of possibilities would be provided. I will introduce very briefly what where we are now and what has been achieved so far. This questionnaire, well, I'm of course not quoting it, so when I will give you some slides in my long presentation, you will see more on it, but it's not literally the text of questionnaire, it's more elaborate. It has 7 parts, and the first part, besides that, is terminology. Terminology is a real challenge. Everyone who ever, I look at Adrian Ward, everyone who ever, or at Philippe Le from the Hague conference, who ever been dealing with this subject know what a challenge terminology is. Then the general part, limitation of legal capacity, if any, state audit measures, everyone has that, voluntary measures, most of the jurisdictions have that or wish to have, ex-legal representation, also not every jurisdiction has that, other private law provisions that can be used, and general assessment of legal system in terms of protection and empowerment. So when terminology starts, when we had these quick scans, we saw that everyone uses, of course, English language. And most of the countries, of course, are not English speaking. So they translate their own national terminology into English. Sometimes they use the official translations that have been provided by the government. Sometimes then they invent something. And then we see really a Babylon situation, Babylon Tower situation. Everyone is in, some translate the same thing as guardianship, other is curatorship, then tutorialship, then whatever. And why? Because something that guardianship, well, but we just, it's not really old-fashioned guardianship what we have modernized it. So we will translate it somewhere differently. So if you look, the term guardian has been deliberately not used in the questionnaire because it now has almost no function. Everyone could be hidden after the behind this guardianship, from the very old-fashioned, completely unchanged substitute decision-making institute to the modern institute that has been modernized, but the term has not been changed. So we asked the members if you use the term guardianship because the terminology has been changed, not been changed, or because this is the official translation in your jurisdiction into English, please just explain. This is what comparatives do. Don't just use the term that is not completely fitting, but explain, give short list of definitions so that we can come back to that. And also provide not only the English translation, but also the terms in your original language, if necessary, even if your original alphabet. And besides, we also try to use as far as possible the terminology of the Crpd, of the general comment, of the Council of Europe recommendation, so that we would not stand alone. But what a real challenge for all of us is for the future is to develop coherent set of English terms for this institution that could be used without confusion all over the world and all over Europe. And that we can do only with the other entities, of course. Then questionnaire general part, I will stop a little bit more on that, because if you look at that, you can see the scope of the ambition of the FL-EUR. And so it's not only the black letter law that FL-EUR is interested in, but also the policy and historical background and the current situation. So it's law plus how the system came to where it is. What was the inspiration? What was the discussions? Then the question how the system operates as a whole. That's interesting and important that the speakers, that the reporters would do that themselves rather than we would deduce it from the report, the detailed report, because it's very, very easy to misunderstand some things, especially when the system is not very familiar to us. Brief description of legal sources and in any empirical information and statistical data available. Some countries already have empirical evaluations, and empirical legal studies is really something very new from the last probably decades, but it's spreading everywhere, gaining in importance, and the lawyers are no longer doing something without any knowledge what impact it has, and also without the previous studies. We try now to build on empirical knowledge and to look immediately at the impact of the legislation. So post-evaluations and pre-evaluations, and if there are any of them available, we really would like to have them on board because they are very important to know how the system really works. Then we would like also to know what is the new current political, legal, ideological discussions surrounding the change, the reform, the current situation in particular countries. Because the quick scan has already shown us that with these European jurisdictions, they are, well, we are now in 2021, and the quick scans are dating from 2019. So I didn't want to present to you the results because some countries have already moved forward. But basically, we see European jurisdictions who have changed their system already prior to adoption of CRPD, the system that have profoundly changed their system after they ratified the CRPD system. They had a kind of patchwork solutions that they have changed here and there, like the Netherlands, but not really had a profound change. System that have drafts and bills of law and that are in process of change, contemplating change, and systems that have not done yet anything. So we have a whole range, a whole scale of systems, but all have ratified the convention, so committed themselves to change, and therefore they need to go into this process. So we see the evaluation and pending and future reforms. This is general system. Then limitation of legal capacity, if any. So first of all, it's asked whether your system still permit limitation, and if it permits, then on what grounds, what is the scope? Does this limitation automatically affect legal capacity, or you can have it tailor-made? And then how can you restore it? And also whether application of measures, especially state-ordered measures of legal of adult protection, automatically result in deprivation or limitation of legal capacity, or it allows also a tailor-made solution by a judge or a competent authority. But also, are there any other legal instruments that could in fact lead to the prevention or limitation of legal capacity? Because what we suspect or some fear is that some countries could kick publicly limitation of legal capacity from the front door and then let it in through the back door by means of application of some rules of contract law or some rules or family law. Because if you say, for instance, that to be a guardian of a child, you need to be fully legal capable, or if you don't have this term compos mentis, and you don't have it, whatever you say in your system about possibility to limit legal capacity, in fact, it would be limited here. And then evaluation of the problems. Then we have the system of state audit measures. It's quite easy. There is not much surprising to say here, but here again, how any measure affects legal capacity of the adult, and safeguards and supervision and reflection and evaluation. Of course, this is that goes for any of the subjects. Voluntary measures. Not everyone has it, and when we see what the countries have, we see a great variety. Then, well, we have definition. We ask them to to define the measures. Basically, you can have a possibility to appoint a self-chosen representative or support person for event of the future incapacity or impairment that could make it difficult for you to manage your own affairs. But you can also give advance directive without having representative, or combine those two. And then what is the system? What are the legal sources? In some countries, it's not regulated by law, like for instance in the Netherlands. And who can grant this voluntary measure? What are the requirements? How and when they enter into force? It's a challenge, because to make it, to initiate it, you need to be compos mentis, and when it starts, it might be not the case. How to see when it's so far? And then who can be appointed? Can several persons act simultaneously? And another interesting thing is the supervision and legal effect on the legal capacity. How these representatives or support persons act? Do they act together? Do they act as support? Do they act instead, or can they do both? What effect it has on legal capacity? Does it differ from according to whether it's property and financial or personal and family matters, care and medical matters? And as well, what criteria are used for decision making, best interest or own will and preferences? And what is the subordination if both principles are used? And then guarantees and supervision is very important, especially for that measure, because it's voluntary and it should be easy and easily accessible. Otherwise, it loses its point. And at the same time, protection is absolutely mandatory. Then I'm skipping because of the time, the other private law measures and ex lege. And I'm going to the evaluation, self-evaluation of the system. So the reporters are asked to evaluate their own systems using all available materials, the reports or reports to Crpd, to the other organization, literature, political discussion, and to look themselves at whether the transition has been made from substitute to supported decision making, whether the autonomous decision-making prevails and substitute decision-making representation, if it's still possible, is really used as a last resort. On proportionality, whether it's really tailor-made, whether support decision-making or limitation of legal capacity, if admitted, is really used as last resort. Then effect on legal capacity, possibility to provide tailor-made solution, and transition from best interest principle to the own will and preference principle. And then also, we know that these are communicating vessels, protection and autonomy and empowerment, because if you have more empowerment, then it could have effect on protection and other way around. And the CRPD requires both, mandates both. So then when assessed from the point of view of empowerment, the assessment from the point of view of protection should be made. So is it due during the deprivation limitation, during the application of the measure, during the operation of the measure, that the adult is duly protected against her or his own ill-conceived acts, against the conflict of interest and abuse by representative support person, against conflict of interest, and for instance, when the residential care institutes are still guardians in some Eastern European countries where it's a great issue still, like Russia and Bulgaria, where this is one of the most painful remaining points that needs rapid resolution and the protection of privacy. So this is basically how reports are structured and what is expected. And I think after the reports would be published and the results would be initially organized, the new conference would be organized to share these results. And of course, you all will be invited to share it, to discuss it with us and to evaluate what has come from it. So thank you very much. Any comments are most welcome. You can just use this address. And thank you very much. Thank you very much, the co-organizers, and for making this possible, and for all of you to for coming and listening.
Thank you very much, Masha, for this first introduction into the complex endeavor that FL-EUR is embarking upon of doing collaborative research on adult protection law from a comparative perspective. So we will have the occasion to discuss more deeply these issues and in further sessions. And it is now my great pleasure to welcome Markus Schaefer, who is a professor at the University of Basel for constitutional and administrative law and a member since January 2019 of the UN Committee on the Rights of Persons with Disabilities. We invited Professor Schaefer to this conference, particularly in his role as a member of the CRPD committee. And let me introduce his specialization to you. He is a leading scholar on fundamental rights and on the rights of persons with disabilities in Switzerland. He has also ample experience in drafting disability legislation, which is interesting for our context, of course, as well as evaluating and implementing it. So he has an experience in this evidence-based approach that Masha has also sketched. And he regularly and closely works with governments and civil society organizations on disability issues. And he is the author of a comprehensive treatise on Swiss disability law, as well as on another treatise on constitutional rights. So he brings this fundamental rights perspective to our debate, to the disability rights perspective. And without further ado, I give you the floor, dear Markus.
Thanks, Michelle, for the generous introduction. Good to see you. Haven't seen you in a long time.
Yes.
I was told by the organizers to confine myself to 3 slides, and I will comply with that request. I will start with I'm still a bit fighting with the technology here, but I'm sharing the screen now, which is this one. Can you see it now? No,
not yet.
I have to. Now you can see it.
Yes, perfect.
All right. At the core of the topic assigned to me today is, as has already been mentioned several times, the guarantee of equal recognition before the law. It is guaranteed in Article 12 of the CRPD. Later on in this conference, a presentation will be given on the particular aspects relating to Article 12. I will focus myself on a few main ideas behind the provision. And as the CRPD Committee's jurisprudence on legal recognition receives strong resistance, particularly on the domestic level, I will start out with a few comments on how we in the committee form our opinion. The committee has grappled with the issues of Article 12 in 4 different types of procedures. First, there's the state party reporting procedure. Based on a state party's report, organizations of persons with disabilities, alternative reports, reports from other UN agencies, extensive bilateral meetings with organizations of persons with disabilities, I will refer to them as OPDs, and a dialogue with the state party delegation of 6 hours. The committee drafts its concluding observations with recommendations to the states. This far, we have conducted 94 such procedures, all of which also pertain to Article 12 and the guarantee of equal recognition before the law. Based on this jurisprudence, the committee has, as has already been mentioned, issued its general comment number 1 in 2014. It is the result of a process of about 2 years during which extensive internal deliberations took place, external expert witnesses were heard, the views of the other UN treaty bodies were included, and which was open to public comment. We are currently in the process of drafting guidelines on a very closely related matter, and for this purpose, we have had hearings with more than 550 organizations of persons with disabilities worldwide, and we will shortly open the draft for these guidelines for public comment, or maybe they have already been opened. I'm not quite sure. Then third, the committee conducted an investigation into the situations of persons with intellectual and psychosocial disabilities institutionalized in Hungary. A delegation of the committee visited the country for 2 weeks and interacted extensively with the legislative, executive, and judicial branches, or OPDs, other NGOs, lawyers, social workers, etc. A large number of institutions were visited, and interviews with inmates were conducted. Then the 4th procedure relating to adult protection have been central in individual communications. The most recent case decided this August was issued against Hungary. In these proceedings, the internal process in the committee resembles that of a court. I am the rapporteur of the working group on communications, and in that capacity, I prepare the drafts together with the petitions unit of the UN. And it's a function that closely resembles that of a judge who is assigned to write the opinion for a case. Now, the committee's jurisprudence is the result of these procedures, constantly re-evaluated over the years. It is based on extensive factual information on a worldwide basis and discussed and tried in a great number of proceedings of various forms. Now, after these organizational and procedural remarks, let me move on to the most fundamental substantive issues here. The main legal problems of adult protection from the perspective of the CRPD do not form part of adult protection law itself, but are rooted in the law of the capacity to act, as it is, for example, laid down in Articles 12 and the following of the Swiss Civil Code. To address them, we need to get to some fundamentals of the CRPD. First, very basic provisions in the CRPD, a very basic provision in the CRPD relates to the question of what it means to have a disability. Article 1, Section 2 does not contain a definition, but an exemplary illustration. As you can read, persons with disabilities include those who have long-term physical, mental, intellectual, or sensory impairments, which and now the important part comes, in interaction with various barriers, may hinder their full participation in society on an equal basis with others. Now, this provision lays down a social understanding of disability. Disability not as an inherent medical condition that prevents a person from participating in society, but the consequence of a social or technical environment geared towards people without impairment, with the result of the person who does have an impairment being excluded or treated worse than others. From this perspective, you could argue that it's equally the impairment on the one hand and the barriers on the other hand that need to be taken into account in the determination of the measures to take in order to avoid a discrimination. And this indeed is the approach usually taken under domestic constitutional law and, for example, by the European Court of Human Rights under the European Convention. However, this is not the approach taken under the CRPD. To understand why, we need to start with the main goal the CRPD is designed to achieve. The CRPD aims at fully protecting the human rights of persons with disabilities as they are protected for everybody else. This goal does not only pertain to classic civil and political rights, but also to social, economic, and cultural rights. Equality and the protection of all rights guaranteed by the Convention is its central goal. Restrictions based on disability are impermissible. The text of the CRPD reflects this approach with a qualifier on an equal basis with others. In most of its substantive provisions, you can read through the ones I've mentioned here, you can read through the Convention, and you will have this annoying repetition of on an equal basis with others. It is a deliberate attempt to clarify that the equal enjoyment of human rights is the central goal of the Convention. Now, there are mainly two types of guarantees that do not contain this qualifier. They are either provisions that contain absolute guarantees or that aim at protecting from all forms of certain infringements. An equality qualifier would be nonsensical in these situations. Let me give me two examples. Article 15.1 prohibits torture or cruel, inhuman, or degrading treatment or punishment. It does not contain the qualifier on an equal basis with others. The qualifier would be unnecessary as the corresponding guarantee of the prohibition of torture and inhuman or degrading treatment or punishment, as, for example, laid down in the ICCPR in Article 3 of the European Convention or in the Article 5 of the American Convention on Human Rights, are absolute. So you don't need the qualifier. The second exception, among others, is Article 16. The obligation to take all appropriate legislative, administrative, social, educational, and other measures to protect persons with disabilities from all forms of exploitation, violence, and abuse does not need the qualifier either. Here, the reason for the omission lies in the aim to protect from all forms of abuse. If you need to protect from all forms of abuse, you don't need the qualifier. Now, with this concept, the CRPD deviates substantially from traditional international human rights law and usually from national domestic constitutional law. The most important change relates to the core of what prohibitions of discrimination guarantee. The CRPD prohibits the use of the concept of disability as a grounds for infringing on an individual's right. This seemingly radical concept responds to the experience of decades under traditional human rights law. To this day, under traditional human rights law, infringements on individual rights because of a person's disability are open to justifications relating to the protection of countervailing interests, irrespective of the character of the interests. Even financial considerations or considerations of administrative convenience may be used as justifications. And this is true in all areas, from political rights to deprivation of liberty. As a result, persons with disabilities are disproportionately subjected to measures such as the removal of their right to legal capacity to act, of their right to liberty, access to justice, and most other rights. The track record of the European Court of Human Rights, for example, with respect to guaranteeing the rights of persons with disabilities under the European Convention is highly questionable at best. On the UN level, the CRC, the Committee on the Rights of the Child, and the CEDAW Committee have substantially promoted rights of persons with disabilities. CAT, however, the Committee Against Torture, has remained in the traditional approach of guaranteeing mainly procedural rights in cases of deprivation of liberty. And currently, in the Council of Europe, the efforts to draft an additional protocol to the Oviedo Convention remain in the same mode. With respect to adult protection, as I have mentioned, Article 12 of the Convention lies at the center. Persons with psychosocial and intellectual disabilities frequently lose their right to act and to exercise their right. The reasons for the removal are generally seemingly benevolent. The consequences, however, are far-reaching, particularly in situations of comprehensive guardianship. However you define the term, we in the committee are constantly exposed to the situation of, 184 member states that all use their different types of terminology. Nevertheless, one of the most essential features of human beings, as conceived by the Enlightenment, is the possibility to govern oneself. From it, the exercise of all human rights follow. It forms the basis for what human beings are and why they are different from animals. In it lie the reasons for a person's autonomy and her dignity. Removing it from the person strips her of the most foundational trait as a human being. Even the most benevolent motive cannot, under the CRPD, justify it. I would remind you of my brief sketch of the social understanding of disability at the outset of my presentation. The remedy for the transformation of an impairment into a disability is a change in the environment, not measures impacting the person with an impairment. The state is required to provide the support measures necessary to allow persons with intellectual and psychosocial disabilities to manage their lives, but it must not, at the same time, infringe on their rights in manners it does not in the context of persons without disabilities. Removing the ability to act is, under the CRPD, such an impermissible infringement. I am keenly aware that the requirements of the CRPD are fundamentally at odds with the conception of legal capacity laid down in many domestic codes, and whether be they civil law or other countries. I'm also aware of the myriad of consequences flowing from the removal of legal capacity, not least in adult protection. The gravity of the differences is not confined to adult protection. However, the differences between the CRPD and national domestic law, but it extends to most areas in which the CRPD applies, be it access to buildings and services or inclusion in regular schools. So adult protection or the more fundamental issues of legal capacity are no outliers in the convention. They go along quite well with the other areas. They are a reminder that the idea that persons with disabilities are bearers of human rights on an equal basis with others is still in its infancy. An assessment illustrated by the fact that the CRPD only turns 15 years old this December. As the struggle for gender equality exposes, changes in law and society relating to persons deemed to be inferior need inordinate amounts of time. It was only in Switzerland in 1988 that marriage law was based on the principle of equality. And that was more than 140 years after the first emancipation law of the canton of Bern was enacted. I assume it won't be much different with persons with disabilities and their capacity to act, even though I would hope. Thank you.
Thank you so much, Markus Schaefer, for this important call to really take seriously the spirit of this convention and the new ideas and also renewal of human rights doctrine that it brings, and the idea of equality. Your talk will guide us through the day, I think, and will be an important orientation also for FL-EUR's work. So thank you so much for giving us this insight into the committee's thinking and the interpretation of Article 12 CRPD, namely. So as we announced, we don't have a discussion now. There will be discussion periods, long discussion periods in the next session. So we are taking a break until 11:15. So you're free to grab a coffee and refresh yourself, and we will be back at 11:15, and Professor Frederick Swevenen will take over the moderation then. So have a nice break, and thank you again to both speakers, Masha Antokolskaya and Markus Schaefer, for your great introduction into the topic.
So I think we're ready for the first substantive session on the basic concepts, key concepts in adult protection law, as Masha Antokolskaya explained during her introduction earlier this morning, particularly when comparing legal systems. A good and shared understanding of the key concepts in adult protection law is quite important. And in contemporary scholarship, I think these concepts are much inspired by what we can learn from the UN Convention on the Rights of Persons with Disabilities, as Professor Schaefer has introduced us to in the introductory session. We have 3 presentations during this session, and then we have quite some time for discussion. You may feel free then to share your video and audio and put your question to the speaker you want to, or if you want, you can also share it in the chat function, and we'll see how we go about then. 3 presentations. We have 3 speakers. The first is Dr. Eva Marchat, who throughout her career has worked on the topic of today's conference, particularly on the United Nations Convention, first as a project assistant at the University of Innsbruck, then at the University of Kassel in the Department of Social Law, and subsequently as a Max Planck Fellow, or in a Max Planck Fellow group on discoverability and indicators for inclusion. She has also taught as a research assistant at the Chair of Sociology of Diversity in Munich. Now, Dr. Marchat is working as a lawyer at a research center on vascular aging and stroke in Austria. She will be our first speaker on the concept of legal capacity. Afterwards, we will have an introduction in the concept of own will and preferences as put forward by the UN Convention, and that concept will be clarified by Professor Paula Tavrat-Vittor, who is a professor of family law and succession law at the University of Coimbra and a researcher in the Institute for Legal Research there. She is also a member of the coordinating group of our FL-EUR, Family Law in Europe Academic Network. She's also a member of the Executive Council of the International Society of Family Law and of the International Academy of Comparative Law. She is also involved in Portugal and in different legislative initiatives moving forward to the modification or modernization of Portuguese mental health law. She was also involved in a conference that was organized under the European Union auspices as to the European Union possible initiatives in this field that concerns private international law. Then our third speaker for this session on the proper role of the state as a guardian is Professor Velina Todorova, who is an associate professor on civil and family law at the law faculty of Plovdiv University and a member of the Bulgarian Academy of Sciences. Who has a quite broad experience in researching topics of family law from the human rights perspective. She too is a member of the coordinating group of the FL-EUR, and more importantly, I think she, besides her academic career, she has also broad experience in NGOs and in activism, particularly now as a member to the United Nations Committee on the Rights of the Child. So these are our renowned speakers of this session. I'm sure they will share interesting presentations, that is summaries of the presentations I was able to see beforehand, and you too, and that will remain online on the website for those interested. Now, I'm happy to first give the floor to Dr. Marchat.
Thank you very much, dear ladies and gentlemen. Thank you, Professor Svennen. Just let's jump right into the topic. In this presentation, I just switched the mode. Does it work? Yes. Okay. In this presentation, I will look at the term legal capacity itself and then highlight the different concepts which are contained in the term, as well as we also take a brief look at the Austrian structure of legal capacity, just as an example. The entire drafting and development process of the UN-CRPD has been a remarkable process. The English term legal capacity chosen in the convention summarizes the legal personality and the legal capacity to act. On the one hand, the term refers to the ability to be the bearer of rights and obligations, and on the other hand, to act legally on this basis. Utilization according to the model of Article 16 of the Civil Code from 1966. This applies to every human being and encompasses all areas of life. Legal capacity is understood as a concept of legal capacity and legal action. During the negotiation around the convention text, there was a lot of debate about the importance and the meaning of the term of legal capacity. There was a disagreement over whether legal capacity should be understood as the ability to perform legal acts or the ability to be a subject in law, or both. Because of this background and of different languages in connection with the different legal systems, the negotiators agreed to avoid misunderstandings that the recognition of legal subjectivity and equal performance of legal capacity should be accommodated in two separate paragraphs, Article 1 and 2. Recognition of legal capacity is regarded as a fundamental requirement for exercising civil, political, economic, social, and cultural rights. Legal capacity thus plays an important role in all areas of life. Another aspect that should not be underestimated, as it was mentioned earlier, is found in the different legal systems. This should always be considered individually with the respective national and cultural backgrounds. As far as can be seen, no universally valid definition of legal capacity that transcends national borders is known. An internationally recognized definition of legal capacity has not yet been formulated. The Commissioner for Human Rights of the European Union uses also the English term legal capacity and describes it as a power and opportunity to act within a legal system. So let's jump to the different concepts. The concept of legal capacity should be distinguished from the concept of mental capacity. The mental capacity refers to a natural ability of a person to make a decision. This natural ability can be different for each person. How the natural ability is shaped depends on environmental and social factors. The Convention first emphasizes the distinction and separation of the two concepts. Among other things, it is clearly stated that the presence of a disability must not automatically lead to the limitation or withdrawal the legal capacity of a person. This thought refers back to the medical model as a deficit approach in which disability is seen as a personal defect or default, what the Convention is clearly against. So far, the national concepts of legal capacity can be understood as a social legal construction that in some cases suggests that people with a disability lack legal capacity because of disability due to a medical diagnosis. This assumption implies a certain value attached to this group of people. The concept of mental capacity comprises the following element. As it was mentioned, the general comment number 1, and also linked to this, the Austrian legislator mentioned the ability to make decisions include 3 essential elements: the cognitive one, the voluntative, and the ability to act appropriately. In the past, legal recognition is still often reduced or even denied by a legal system, especially to persons with a disability. The concept of legal capacity and mental capacity are often mixed up in legal systems. These are legal systems that base their laws on the medical model of disability. Mingling can lead to the assumption that a person's mental or psychological disability, the natural decision-making ability is impaired, and consequently, the legal capacity to make concrete decisions is denied. The refusal of the legal decision-making capacity takes place consistently. That is usually without investigation of the individual case. In Austria, as a national example, we have a kind of hierarchy of the different legal capacities. You can, or we use legal capacity as a kind of an umbrella term. And then on the next step, we have the capacity to contract. And what is more interesting is the capacity to give consent, for instance, to medical treatments. In the past in Austria, the terms capacity to understand and capacity to assess were used predominantly as main terminology in the field of giving consent to a medical treatment. And the second adult protection law brought a new concept of decision-making. The capacity to consent is also described as ability to make decisions. The term capacity is also connoted to the term competence, but it should not be ignored that it takes place in a legal as well as a medical context. So we have a kind of interdisciplinary context. The definition of the cognitive elements of capacity is composed of a combination of the following elements. To understand the specific situation, relevant facts or basic information about choices, to evaluate reasonable implications or consequences of making choices, to use reasoned process to weigh the risks and benefits of choices, and to communicate to stable choices. Regarding legal areas, this means we have three elements which were important for the ability to grasp the benefits of interfering with a legal good. Second, the ability to rationally assess the associated risks against each other. Just finally, it is very important to be and the legal elements in the diverse contexts. In my opinion, the element of support in the form of supported decision-making must always be taken into consideration, especially when it comes to the assessment of a natural skill as a result in legal capacity. This means the required and adequate support within the scope of decision-making or assessment is broadly missing. And finally, I really believe that significantly more affected people with the necessary and appropriate support will be in the position to make their own legal decisions. So just a short, brief overview of my long presentation, which you can see online. And thank you very much for your attention.
Thank you very much, Dr. Marchat. I must admit, in my course on international family law in the new Austrian law of 2018 was one of the best practices we shared amongst the students. There's also very good overviews, brochures in English available on the Austrian Ministry of Justice. It's really a very interesting act, the different pillars in the act. So I hope we can discuss on this later. To the audience, should you already want to put a question to Dr. Marchat, please do feel free to already share it in the chat, and we can put some order in it if necessary. And meanwhile, I'm happy to give the floor to our second speaker, and that is Professor Paula Tavra. Vitor, you have the floor.
Thank you so much. It's such a pleasure to be here in this much anticipated conference. And I'll just share my screen and bring you my topic, what is own will and preferences, which is one of the concepts brought to us by Article 12, the heart of the paradigm shift of the CRPD, that proclamated the universal capacity paradigm and the support model as necessary approaches towards capacity as a human rights issue. So this reference to will and preferences is a discrete one in Article 12. It is inserted in the middle of a complex array of guarantees, but I dare to say it is the key to the core of the new paradigm. It is an instrumental concept that allows us to dig deeper into the implication of these proclamations. So the first question is, what can we understand by the person's own will and preferences? well, it seems that this would be an issue for philosophy and brain or mind sciences, but it is also a legal concept and it has to be interpreted as such. And the primary source of interpretation is, of course, the general comment number 1. And the general comment makes a negative approach towards what will and preferences are. It presents it as a barrier towards coercive interventions, be it forced treatment or guardianship, and as opposed to the best interests of the person, that paternalistic criterion, traditional paternalistic criterion, which ultimately means that it refuses to import external criteria, and also that first and foremost, we are talking about will and the preferences of the person, and as opposed to third parties' interests. And this will and preferences may be expressed. The most relevant moment is the present. It is the necessary consequence of recognizing capacity and the possibility to make one's own choices, but also in the past, because the committee itself recognizes the right to engage in advanced planning and to need to ensure it on an equal basis with others. Another question regarding, this concept is how to determine the will and preferences. Well, of course, the first level is the direct speech, without the mediation of a third party, even if reasonable accommodations might be necessary, such as providing information in an understandable format, recognizing diverse methods of communication, or even advanced planning. But it is also closely related to the exercise of support. The support person may play here a facilitating role, as Minkowitz puts it, which may encompass a series of different activities, assistance with communication, decoding relevant information, and ultimately exercising a maieutic role regarding the will and preferences of the person. And finally, in order to determine the actual will and preferences, these have to be protected from undue influence. And what are the implications of electing the will and preferences as the decision-making criterion? Well, the first implications are negative, as we have seen. Will and preferences have been elaborated as a barrier towards coercive intervention. So it means to refuse classic guardianship schemes and to refuse coercive treatments. And it also has implications as in the recognition of a right not to be supported. But it has, of course, also positive implications. We may say that the will and preferences are the key to the exercise of support. The general comment itself mentions that the forms of support in the exercise of legal capacity must be based on the will and preferences of the person, and not on what is perceived as being his or her objective best interests. Thus, at a principle level, we may say that support is marked by the respect for human rights, but from a technical point of view, it is the respect for the will and preferences that characterizes it. And finally, it also implies it's also the basis for the proclamation of the right to live independently in the community, but also the right to make mistakes and the right to take risks. And these are the main lines and the most widespread ideas about the meaning of the respect for will and preferences. They result from the text of the convention itself, but given its condensed expression, the main developments have been made in the general comment. That has been very strongly aligned with a very clean interpretation of the principles of the new paradigm. So the next question is, how can we comply with these clean lines of the new paradigm? And so it can be argued, of course, that the interpretation given by the committee in the general comment sets aside all possible doubts because it is very clear in its demands. And it is true that the general comment is, of course, the most relevant source to ascertain the meaning of these rules. However, of course, the authorities of the general comment does not eliminate discussion. And even more because Article 12 is often characterized as being ambiguous and resulting from a negotiated silence. Therefore, I would propose that we would reflect on a few issues. The first of all is will and preferences as a barrier to guardianship schemes. And as I have already mentioned, the approach to the new paradigm given by the general comment is a negative one. The new paradigm is the reverse of the old paradigm. And this old paradigm has in common some characteristics, including the decision by the substitute decision maker is based on the objective best interest as opposed to being based on the will and preferences of the person. So I would argue that substitute decision making per se, the process of making decisions in the context of the old paradigm, is not defined by the mechanism, how it works, but rather by the criterion, why it works. So the old paradigm is grounded in the objective best interests. A new paradigm demands the criterion of the person's own will and preferences. This would therefore allows us to ask whether representation as a mechanism that is not denied in the context of advanced planning, for instance, would still be substitute decision making when the criterion is adopted is not best interests, but rather the one of the person's own will and preferences. The second issue refers to the role of will and preferences as a barrier to forced treatment and by psychiatric and other health and medical professionals. This is a highly sensitive matter. We know that forced treatment is often the stage of gross violation of human rights of persons with disabilities. And since the UN CRPD, several mental health laws have been reformed. However, despite these changes, not all forms of involuntary treatment have been eradicated. And given the fact that there are conflicting rights, the right to health, the right to life, that have been summoned into equation. And of course, there's a new element that has been mentioned today, the draft of the additional protocol to the Oviedo Convention that will allow us to dig deeper into this question. The third issue is the best interpretation of the will and preferences. The committee has recognized that it's not always practicable to determine the will and preferences of an individual, and when not even the best efforts make this determination effective, then the best interpretation of will and preferences must replace the best interest determination. This could mean, for instance, that in cases of dementia or coma, the analysis of the sedimented life preferences of someone would allow us to create a construct based on these elements. However, there are situations in which we have more severe disabilities, and this expression may have never had the opportunity to occur in such terms. And there is also another issue to be debated, that's the possibility of conflicts between the will and the preferences of the person. And both these issues have been have deserved some attempts of solutions that I have addressed in my full conference. And finally, how can legal systems of states that have ratified CRPD comply with respect for this criterion? Because as we know, several countries have reformed their classic regimes, some of them in order to comply with CRPD, but not every aspect is in accordance with these demands, namely with this one. In the longer version of this conference, I confronted a few examples, and I had the opportunity to propose the interpretation of legal internal rules in accordance with the UN CRPD that implies to value every manifestation of the person's wishes as a primary reference. That means that even when the phrasing of a legal provision does not seem to express correctly the will and preferences criterion, one should take into account the systematic element, and if still supported by the rule, interpreted in accordance with the CRPD, so that its actual practical application does not contradict binding international law. And that is actually a challenge that I urge each of us to think within our own systems so that we look for the legal solutions that do not put at stake the respect for the autonomy of people with disabilities and propose within the system ways to promote it. Thank you so much for listening to me. I know that these reflections are a work in progress, and of course I'm ready to face all your comments on such a controversial issue. Thank you so much. Goodbye.
Thank you for this very interesting presentation. And I see quite some links also with the presentation by Dr. Marchat. And there is already one question to Dr. Marchat in the chat that maybe you, Professor Tavra-Vitor, can also look at on the. I think what a fundamental problem might be is which standard you use to assess the legal capacity or the will and preferences. For example, each manifestation of a will, is that a reliable indicator or not, particularly in the context of medical treatment? I see more questions popping up in the Q&A. Please do feel free to also already put your questions to Professor Tavra-Vitor in the Q&A. And now I'm happy to give the floor to Professor Velina Todorova. You have the floor.
Thank you. Thank you, Frederick. I would like to share my presentation. And while doing that, I would like to say how privileged I feel to be in this company of distinguished scholars. Okay. So before starting, I would like to add to my personal presentation. I was very much involved in the Bulgarian reforms under the CRPD. We produced a very good draft law, which unfortunately is pending for 5 years at the parliament, and Bulgarian parliamentarians do not have the courage to introduce it for discussion. So the aim of my presentation is twofold: to focus our attention to this outdated and denied in many European countries practice, but at the same time not to forget it and its lessons when it comes to the choice of assistants and support persons of vulnerable adults in exercising their legal capacity. So in fact, I will rather speak about the improper role of the state as a guardian and hope that this, I am sure, least attractive presentation will be a thought-provoking. Most often, the term guardian is linked to substitute decision-making and deprivation of legal capacity. And also, not only of legal capacity, but also to deprivation of liberty of the vulnerable adult. I will speak about this later. Still, the term and the concept mirror a practice that is applied in some European states when the state becomes a guardian. The quick scans of the systems in 27 European countries suggest that, for example, in Bulgaria and in Russia, maybe also in some other states, the state's responsibility to provide care to vulnerable adults can be realized by placing the vulnerable adult in institution, and the same institution takes the role of a guardian. The practice doesn't change no matter if the institution is private or a state-run. In this way, the institutional representation or guardianship becomes one of the adult protection measures. It could be established ex lege or as a state-ordered institutional representation of persons in residential care. Institutional care in some states is the most frequent type of care, often due to the chronic failure by governments to establish a legal right to live independently and be included in the community, and the failure to invest in access to regular housing stock and individualized community support services. And the guardianship appears to be the short avenue to the institutionalization of vulnerable adults, because it provides for an easy or convenient solution of the issue of consent for the placement, but also to the lack of other types of care. That is how the state guardianship becomes a solution in two problems: provision of care and legal representation of vulnerable adults. So with this, I would like to strongly focus our attention on this interrelation between care, the right to care, and a right to representation, and which poses many issues toward, for example, this so-called voluntary placements, paternalistic approach to care, and legal capacity of vulnerable adults, etc., and many others. I think that these will be part of our discussion. In this case, when the state becomes a guardian, the duty of care is conflated with legal representation, and often the wills and preferences of the adult are not taken into account at the expense of the interests of the institution. The principle of the independence and impartiality of the person providing support to the vulnerable adult is compromised. For example, the institution or the director is given the right to manage the person's finances, including part of the pension, to set the daily routine of the adult without regard to his or her wills and preferences. The access to court, for example, to change the guardianship is fully dependent on the guardian, which is the institution. The European Court of Human Rights, in its jurisprudence, found numerous violations of the rights of vulnerable adults placed in institutional care, and having as guardian the institution itself, namely the rights of the rights to be free from torture and degrading treatment, right to liberty, and right to a fair trial and access to court. There is also a potential violation of the right to respect of private life, as it appears from one dissenting opinion in the case of Schaefer versus Bulgaria. And there is a quote from that judgment, which makes this clear link between guardianship and deprivation of liberty in the institutions. I can give another example, which is also on the screen. It's from a report of the issued by the European Committee on the Prevention of Torture and Degrading Treatment that visited the institutions in Bulgaria 10 years ago, and found that a violation of the rights, mixing up the care and legal representation of the vulnerable adults placed there. Above all that I already said, there is usually no system of monitoring and accountability for these guardianships, as the institution is only monitored usually on the quality of care by social care ministries, but not the guardianship and the rights of persons placed in the institutions. To conclude, I would like to say, I'm sure we all are aware of that before CRPD, this practice and legislation have not been problematized. The adults in institutional care remained invisible, and so did the violation of their rights. Everything started to change after the convention. Also, the work done by the Council of Europe and the jurisprudence of the European Court of Human Rights actually triggered many changes in this area. Still, in some states in Europe, the situation remains the same or a little changed, which is the case in Bulgaria, although we have a very good draft law, as I mentioned, and in line with the CRPD. So what is the solution? I'm sure all we are aware of the solution. This practice should be abolished and the law changed. Alternative solutions should be found, which will secure the independence and impartiality of guardians, if guardians are still the case. The safeguards should be established also to ensure the support and respect of the person and his or her will and preferences, as we heard about that in the previous presentation. The support for the person should be free of conflict of interest, and individuals concerned should have the right to participate in all the procedures and in their reviews. So this is the solution for the state to become a proper guardian. And having said that, I thank you. I will thank you for your attention and looking forward to our discussions later. Thank you.
Thank you very much, Relina, for this very interesting presentation. This year is the 30th birthday of the Belgian Act that has abolished the link between guardianship of the institution and well, the care of the individual in the institution. So it's remarkable that it is still not solved, this conflict of interest in other jurisdictions. Let us maybe start with the questions that have already been put to the speakers in the chat function. Maybe Velina, you can stop sharing the screen. Yes, there it's now we can see the gallery of participants again. And then maybe first the question of Wendy Schrama to Eva Marchat on maybe a somewhat broader reflection on future issues relating to legal capacity. And if I immediately may add some small sub-question to that, you talked about the capacity to hold rights and the capacity to be an agent of rights, to act in legal relations oneself. As also stressed in the general comment of the committee, but should there not be also more attention to the effective enjoyment of rights of which the individual is holder, even if he cannot act himself? So how is the effective enjoyment of rights safeguarded? And sorry to abuse my position as a chair to add this question to you. Please, you have the floor, and then afterwards I will immediately give the floor to Paula to see if she has additional reflections on that. Eva, you have the floor.
Thank you very much, and I think I'm going to answer all these questions in one. I think it is most important that we as academic researchers and also the FL-EUR academic network is doing some important work on building awareness. As it is also stated in Article 8 of the UN CRPD, which is a very, very important task to do, just to talk about it, to reflect it, to compare legal systems. I think it is a very important issue, and in my experience, it was really, really interesting how people reacted to the topic, to the UN CRPD, and they also sometimes told me, oh, I've never heard about this, but it's very interesting. And so I think just talking about all these issues is very, very important. What is also important, not just talking about it on an academic level, it is also important to talk with the practitioners, with all the lawyers and judges, and because, yeah, just the judges who are judging about people with disabilities in this stage, it is very important that they are aware of all these fundamental concepts of the UN CRPD. And another thing which is very important, we also, and everyone has to be aware that making a decision, and especially legal decisions, it is not so easy. We all know that, because and especially when it comes to persons with disability who never learned to make decisions on their own, as we know from the legal systems, they don't know how to make a decision. And in this case, it is very important to look at this system of supported decision-making and to focus on that. And I think it is also very important to have an individual look on the persons, what kind of needs or in one, at one, or yeah, I don't know how to say. We have to evaluate the kind of support they need. I think it is a very challenging process, which we have to go, and everyone has to go. I think it is also important to have a participative process in this kind of supported decision-making process. And what also comes to my mind is comparing legal systems, and I also did a comparison on the Austrian and German legal system. We both speak German, we use the same terms, but in the legal context, we use them differently. And we really have to be aware of that. So it's very important to have all the backgrounds which may have an impact on the comparison into consideration. So yes, and I think to be a holder and active participant of a right, it is very important to support people to enjoy their legal capacity in all areas of life. Thank you.
Okay, thank you. And I think the comment by Philippe Lorty of the Hague Conference is correct, that it's an evolving concept, just as guardianship is evolving. Let me now switch to Paula Tavra-Victor to see whether, Paula, you have additional comments?
I can make a few comments, and then I do have a direct question to my friend Torbjörn.
Yes, yes.
Yes, I've already managed to read it. So, okay. Well, I do agree that our starting point must be the one that Professor Markus Schaefer warned us about, the equal enjoyment of human rights. And this means that we have to adopt a material approach. Here, it's not at stake formal equality, because formal equality may have implications that may be severe in terms of injustice. So it's better maybe to speak about non-discrimination in this context when we address the concept of Article 12. And this is demanding, of course. It demands necessary accommodation, and it demands discussion, and this is what we're doing here. We're not addressing these issues as dogma. We are discussing them as people who deal with law, and law seeks to find the best solutions for the problems of life, of course. And when I have here two questions. One is more general about amministrazione di sostegno, the second one, and I think it was more general, and there was the second intervention asked about the influence of the Italian law in international terms, and as far as the will and preferences are concerned, we can say that the Amministrazione di Sostegno has been pioneer in this subject also, because in Article 410 of the Codice Civile, you have the bisogni e aspirazioni, so the wishes and aspirations, I think, of the person as the criterion, and this was in 2004, so it is pioneer. Regarding Torbjörn's question and developments in the future developments in Swedish law, maybe I would get back to my last comment of my presentation. And in the full text of the presentation, I've also presented a national example, the Portuguese national example. And the Portuguese law has been reformed in order to comply with the CRPD. It has been reformed in 2018. However, it does not when we look at literally into the disposition that elects the criterion of the decision-making criterion. And the decision-making criterion in Portuguese law from 2008 on is the diligence of a bonus pater familiae. Of course, this is a highly paternalistic, of course, even in its formulation, criterion. It's more, we can identify it more easily with the best interest standard. However, this I do propose that we interpret this kind of dispositions, the Portuguese one and the coming Swedish one, in accordance with UN CRPD. And actually, there's another example that I give in the full presentation. Even when the reference is to best interests, we may interpret it as Lady Hale did in Aintree University Hospital, NHS Foundation Trust versus James. And she considered that the best interests test in the 2005 Act should consider matters from the patient's point of view, and insofar as it is possible to ascertain the patient's wishes. So an interpretation of internal law in accordance to the UN CRPD, taking into account the systematic element, could lead us to value the wishes and preferences and to reinterpret these more traditional containers as best interests and diligence of a bonus pater familias. And as Philippe Lortie mentioned, the wording or the phrasing may be the same, may be a traditional one, but the content evolves. So we should evolve in this, and our work as lawyers and legal scholars is also to propose new interpretations. So, thank you.
Thank you. The risk, of course, is, Paula, that when reinterpreting the own preferences of the person concerned, particularly in medical decision making, that the doctor would reinterpret it in paternalistic terms, and that the expressed will or preferences would not need reinterpretation if they are conform to what doctor thinks best, and in other cases it would be adapted. So there is somewhat a danger in these standards, no?
Yes, and I think that Eva Marchat, sorry, put the finger in the right spot. It is also a matter of re-educating professionals to understand what these concepts are, understanding them and evolving in this.
Okay, we will stick now to the first two speakers. We have an intervention by Jordi Ribot on capacity. So we will end the interventions on the first two speakers, and then we move to the third speaker, Velina, with an intervention by Gordona Stanic and Philippe Lortie, I think, too, and then a reaction by Velina. At the end of this Q&A round, I would invite Marcus Schaefer maybe to also give a general reflection on what we discussed now. But first, Jordi Ribot, you have the floor.
Thank you very much. Good morning, everybody. My point is concerning the question of what is legal capacity. And let me start here by recalling two ideas highlighted in the presentation that are decisive and which are at the same time somehow controversial. On the one side, it is clear that under the Crpd, legal capacity embraces both the concepts of legal personality, capacité juridique, legal standing, but also legal agency, that is the abstract legal power to act within the legal system by enforcing one's own rights and complying with one's own legal duties. That's clear, pretty clear. On the other side, the legal capacity is not the same as mental capacity. Dr. Marchat has said that. And mental capacity is not the same as mental capacity, I understood. Legal capacity is not the same as mental capacity. The latter operates as a general requirement for any valid legal act, and it is thus not an attribute of the person. Dr. Marchat has named the legal concept of Entscheidungsfähigkeit, or decision-making capacity, as laid down in Austrian legislation, which aims at capturing this idea. I understood, but if some clarification is needed, it will be welcome. So these 2 points, on one side, legal capacity, and the other side, mental capacity, or this decision-making capacity. Well, these two assumptions appear to be controversial. The second one, because the legal capacity to enter into a certain transaction or to perform a legally relevant act can be denied on the basis that mental capacity is lacking or seriously impaired by intellectual, cognitive, or psychosocial disabilities. So here a huge dilemma is revealed when trying to fit this idea of decision-making capacity as assessed by competence tests, as you mentioned in your presentation, with the approach taken by the Committee on the Rights of Persons with Disabilities. Let me recall you section 15 of the General Comment number 1, which I briefly will quote, in which they say, the concepts of mental and legal capacity have been conflated so that where a person is considered to have impaired decision-making skills, his or her legal capacity to make a particular decision is consequently removed. This is decided particularly where a person's decision-making skills are considered to be deficient in this functional approach, and this functional approach attempts to assess mental capacity and deny legal capacity accordingly. It is often based on whether a person can understand the nature and consequences of a decision and whether he or she can use or weigh the relevant information. This is the point that you were mentioning in your presentation. According to the committee, this approach is flawed for 2 key reasons. One, it is discriminatorily applied to people with disabilities, and B, it presumes to be able to accurately assess the inner workings of the human mind, and when the person does not pass the assessment, it then denies him or her a core human right, the right to equal recognition before the law. So my concern, and I will end here, is whether we can rid or not of functional analysis when assessing the consequences of the conduct of human beings, regardless of whether they have a disability or not. Can we imagine that decisions and acts of all human beings are valid and effective, disregarding their lack of competence to understand the risks and benefits of their conduct? On the other hand, who is to assess decision-making capacity for certain legal acts? Any person, such as banks or insurance companies, thereby openly discriminating against those who appear to lack such competence? Officials vested with powers to decide on such competence when intervening in legal acts, notaries, registers, a judge when assessing whether a contract was valid or when deciding that what liabilities arise from harmful acts of the person. For me, here there is a conundrum in legal capacity according to Crpd, which lies precisely on this point, and to what extent Article 12 actually challenges mental or natural capacity as a requirement for any legal responsibilities for all human beings. If there is no understanding about that, shared by all actors, the way forward to meaningful reforms of current legal systems could be done. That's my impression. I would like to stress the importance of this concept of mental capacity, mental competence, and whether this is still relevant in our analysis and in the legal operation of the rights of all persons. And to my understanding and experience, I think that this is one of the most important points to be clarified during our endeavor. Thank you very much.
Thank you. Eva, you want to comment on this one?
Yes, of course. Thank you for your comment. And I just want to clarify that I really highlighted, or I want to highlight it. I'm not sure if it was transferred correctly, but it is very important to differentiate between the concepts of legal capacity and mental capacity. They're very, very different. But when it comes to guardianship law or these kinds of, or even the civil code and decision making or legal decisions, these concepts are very much linked together. And when we look at the Austrian Civil Code, we have this new definition, or it became a legal definition even, that decision-making capacity is a natural capacity. It's a human ability, a skill, which I mentioned earlier. You can learn how to make a decision. It's a process. It's not an easy task. It always depends on the context and also on the decision which has to be made. But we have a very strong connection between these two concepts. I know it is very important to separate them, but when it comes to our topic here, they are very strongly linked together, especially when you look at decisions to consent into or to medical treatment. It's very, very important, but I can suggest just to have a look in my longer presentation. There I highlight the differences and some examples. What is the concept of mental capacity and what is the concept of legal capacity in more detail. This just today was a short summary of my longer presentation. So yes, thank you.
Okay, thank you. Let's move now, still within these presentations before moving to the third one, because we have quite some interventions on Velina's presentation as well. But first, maybe go to Ursula Seibert.
Yes, thank you so much. Can you hear me? Okay, thank you. I would like to add some comments to the lack of knowledge and education as a problem concerning, for example, the what the own will and preferences means. And let me give only some examples only. I think it's a huge problem that everyday people do not know some institutions in connection with the full or partial limitation of capacity to act. For example, in the Hungarian Civil Code, there are two new institutions for several years now. One is the possibility for someone to make a prior legal statement in a public deed or a private deed and so on for the future limitation of his or her capacity to act. And it's not used almost at all. I think it's there is no knowledge about this possibility. And another is the same, is the supported decision making without the limitation of someone's capacity to act. And it's the same problem. It's not used according to the statistical data by the Public Guardianship Authority. And another point is the lack of knowledge on the part of the judiciary itself. I could give only one example. For example, in the Hungarian Civil Code, there is a paragraph according to which if someone who is fully limited, who has fully limited capacity to act, but is able to express his or her views, has to be heard by his or her curator or guardian or whatever. So the person who makes the substitute decisions concerning this person. I'm very much sure that the judiciary uses a very restricted interpretation what this phenomenon, what this phrase means, that someone is able to express his or her views. It's just like in case of children, as far as I experience. So I would like to stress that much more so-called, education would be needed. Thank you so much.
Thank you. Yes, and as Nina Detloff correctly states in the chat, this education should be interdisciplinary. Like sometimes like doctors and lawyers seem to be lost in translation on the concepts they use and on the way they interpret each other's frames of reference. Paula, do you want to intervene on what Orsolya said?
Yes, very briefly on what Orsolya said and on what Nina wrote, because actually they are the same kind of comments. Well, I was mentioning when I was giving the other reply that we must drink new wine in old wineskins. Sometimes because we have old concepts and we can recreate them. But it is also truth that when we have legal reforms, sometimes, and the judiciary is here in a hotspot, new institutes and new concepts are interpreted as old ones. And I can give you my national example. Portuguese reform in 2018, full guardianship and partial guardianship eliminated, but the new institute of acompanhamento, which is supposed not to imply limitation of capacity, for instance, has been used by many courts, at least first instance courts, second instance courts have been more up to date with the new demands, but at least in this lower level, they have replicated the old regime using new concepts and just simply not analyzing in a case by case approach and just full lack of capacity, full representation. So that's something that we have to be aware of. Thank you.
Okay, thank you. Very interesting discussion. Now let's move to Philippe Lortie. One of the earlier interventions, I think, was moved towards the presentation by Velina Todorova. You want the floor?
Yeah, very quickly. Thanks a lot. Yeah, no, it's just a question of terminology, and Paula just touched upon the issue. We use old terms, but nowadays a lot of states are actually, modifying the content. So there's a tendency where we talk about guardianship that we actually associated, or there's a negative connotation to guardianship, where many states have actually now have guardianship regimes that are supported decision-making systems. So I really enjoyed when Velina talked about proper guardianship. Is that the way forward, or how do we dissociate ourselves to make the difference when we talk about those old guardianship systems and the new guardianship systems? Because it's very easy to fall into the trap, and many states don't want to change the terms, which is fine. I mean, you can have a guardian who's actually supporting you. That's okay. I don't see any problems with that. And it's just a question of moving forward, understanding that we use old terms, but that we are modernizing the concept. In the same, I just wrote afterwards that, well, legal capacity is an evolving concept. So is guardianship, and I think that we have to understand that and not be bogged down by the terms, but spend a little more time looking
Thank you very
I'd like first to thank Velina for raising this issue, which are very important also for Serbian law. Unfortunately, Serbian law has traditional model of guardianship still. So we have a collective guardian, and this is the manager of a social service institution for accommodation or a person employed in such an institution, and of all the wards accommodating that social service institution. But the Family Act contains some protective clauses or safeguards to ensure a solution of the collective guardianship would be in the interest for each ward. It is stipulated that the ward has to consent to appointing guardian, and hopefully will and preferences will have impact that way. It is stipulated the ward has to consent to appointing guardian, and also this solution has to be in each ward's interest. So in Serbia is accepted voluntary concept of appointing guardian. This means the person may be appointed as a guardian only if he/she has consented to be a guardian. What is the consequence of this concept? The consequence is, in practice, actually there is a lack of guardians. So reality is that collective guardianship is in some situations, some cases, really necessary. Another protection solution is the solution to appoint temporary guardian for the temporary protection of the personality, rights, and interests of wards. One of the situations when it's necessary to appoint temporary guardian is if ward's interests are adverse to the interests of his/her guardian, namely the collective guardian. I think this solution is very important to protect the interests of the ward if his/her guardian is a manager of a social service institution or a person employed in such an institution. And I would like to mention that in another field of law, namely inheritance law, there are also one important safeguard clause which aim to protect vulnerable persons. So, if the person is going to conclude the contract of lifelong maintenance with the person who is taking care of him/her as a part of the profession of that person, it is stipulated that it is necessary to get consent from the guardianship authority for the conclusion of such contract. Thus, if the ward and manager of a social service institution or a person employed in such an institution's guardians want to conclude such a contract, it would be necessary to get consent from the guardianship authority who should protect the interests of the ward. The legal consequence of the contract of lifelong maintenance in Serbian law is that immovable property in one party's ownership would become ownership of the other party after the death of the original owner. This protection clause is of particular interest if the person is accommodated in the institution. And I would like to say that there is another problematic form of guardianship in Serbian law, that is the direct guardian. Direct guardian is the guardianship which is performing by the guardianship authority. The conflict of interest is here possible as guardianship authority is the body which has to control individual guardians, and in this case, it is actually a guardian. So the need for direct guardian is another consequence of voluntary concept of appointing guardian, as in practice there is unfortunately lack of guardians. So this is, I would like to stress, I'm not sure if other countries, maybe Bulgarian and others have this concept or not, but this is still a Serbian solution, and I hope that after this project we would go forward and abandon this traditional model of guardianship in Serbian law. Thank you.
Thank you. Thank you, Gordona. Velina, is it okay that we first take the intervention by Branka Reshtar and then come to you? So, Branka, you have the floor.
Okay, thank you. I'm sorry, something. Okay, so I was carefully listen Professor Marcus Schaefer, or I don't know, he's a member of some committee or something like that. And I would like to share my thoughts. So we started with the change of paradigm. Before the convention, we had a medical model that has been changed to social model on the other side. So if we think about the role of the state, the previous role and the duty of the state was a protection of people with disabilities, pure protection. That was the duty of the guardian too. After the convention, the role of the state has been changed. It is not just a protection of the people with disability, but it is duty to change environment. That is very important. Because if the duty of state to change environment for people with disabilities in terms of a social work, which is a very important discipline in this area, we speak actually about community development. And the community development is a very important issue, how to exercise human rights. And one of the reasons why human rights has often been less than effective is that it has tended to adopt top-down, legally driven approach rather than a bottom-up perspective. What does it mean? It means that it is necessary, it is important to include social work in our research. That means not just to teach social workers about the legal concept or legal framework or human rights of people with disabilities, but also to listen social workers about a reality of a life of people with disability. It is not just a medical issue. It is an issue of the whole concept of life. So I think that it is very important not just to speak about a medical approach to people with disabilities and people with intellectual problems, but also to listen to social workers, to listen about a real life and the reality of life of these people, to understand the whole concept, how to change environment where these people live. Thank you.
Thank you. Now over to Velina.
Well, thank you. Thank you for the, actually, these were not questions, these were comments from the region that from states that have similar systems, but are trying to change and to reform the systems, which is good. I very much agree with the, my colleague from Croatia that about the change of paradigm. Actually, we are talking of a profound paradigm shift towards human beings, I would put it this way, in societies where the value and respect to the person and the human rights of person and the dignity of person is not, how to put it, integrated into the notions of the society, into the state, into the governance. I think we cannot really speak about the reforms in protection and empowerment of vulnerable adults. So I strongly agree that we need to change the whole paradigm towards persons. So I value the changes, the attempts in Serbia to try to develop the traditional model But I would say that this is, I think it's a problem everywhere. How to find the proper support persons in our states, the proper guardians, where we don't have, we have the unwillingness, resistance of the family members, spouses, children of persons with disabilities or vulnerable adults in general, to become support persons or guardians. In this case, it is really very difficult. It's a challenge. In Western Europe, the solutions were found. We are still fighting with this problem. I would put here the dilemma or this debate is, isn't there a conflict of interest if we ex lege appoint the spouse, for example, of the vulnerable adult as a supported person or a guardian? But this is for discussion. So this is what I could say, following the interventions of two colleagues from Serbia and Croatia. Frederick, there is a question, interesting question in the chat related to the CRC, the best interest. Shall I?
Yes, please.
Say something very
yes.
short, very short,
yes.
because I would like to still hear other participants. Well, it is true. The best interest principle is the fundamental principle and right and procedural guarantee in the Convention on the Rights of the Child. As far as we are actually, we have children to decide cases or create policies, etc. Yeah, we know why is it. What is the concept behind? This is the child is a person in development. The child, the capacities of the child are developing. So that is why we cannot give the full autonomy of the child. Rather, we need person to other third persons to decide for the child, but with the very important condition, listening to the views and preferences and wishes of the child, and taking these into consideration in the under the Article 12 of the Convention on the Rights of the Child. And there was a very interesting comment that when the child becomes an adult, when the childhood comes to an end at the age of 18, we changed the approach. So not anymore best interests as defined by decision-making person or authority, rather will and preferences and legal agency becomes important for that person. Well, I'm not going to deliberate to discuss this, but it is a good point for discussion, I think, and we have this the two committees, CRC and CRPD committees, are trying to establish common understanding and common concepts, and so far we don't have any difference in the best interest principle regarding children and regarding adults with disabilities. But it will be interesting if other people have thoughts on that. Back to you, Fred.
Yes, I'm not sure that it's so different, because the best interest, it's like the then House of Lords, or now UK Supreme Court says it's parental responsibilities are a dwindling right. So at first they might be more acting from the best interesting principle, but as the child, also from Article 12, the child itself will decide what's in his best interest in when he's growing up, and his right to be involved in his decisions, in decisions concerning him or her, So I'm not sure whether that's a complete shift of paradigm once he reaches the age of 18. Paula, do you want to shortly comment on that? And then
Yes.
I invite Marcus Schaefer to...
Just a short comment, because it is really a very interesting question. And while reading the general comment, we do notice that the best interest is not vilified when it refers to children. But it is also recognized in the general comment, the idea of evolving capacity. And shortly, just this will interconnect the evolution of the understanding of human rights, juxtaposes, and I think it will have consequences the way we understand capacity for adults. It will have consequences also in the children's field.
Thank you. Dr. Schaefer, you have not required to intervene, but maybe you would be interested to share some reflections on what you've heard in the past session?
Absolutely. Thank you very much for the possibility to comment. I'll make a few comments here. First, to the last issue about how the CRC and the CRPD committees are working together. And we in the CRPD committee do not question the best interest standards for children. We do not apply it to adults. We do have our differences. We are in the process of creating a joint paper of the CRC, and the CRPD. And the main differences there are with respect to institutionalization of children with disabilities, but that is an issue that is more on the sidelines here. So we confine ourselves to the issues pertaining as far as Article 12 goes of adults. Now, it was mentioned that we should start out with mental capacity and then go on to the capacity to act. I would disagree with that. The idea of mental capacity to all of us is of quite a fictitious nature. Who of us can claim herself or himself to be in all decisions relating his or her life in control in control of what they mean. The last time we were at the bank, did we really understand what we signed? I don't think we did. The last time a doctor told us what the risks of a certain operation are, we cannot assess that ourselves. So what I'm trying to say with this is mental capacity is not the linchpin based on which we should assess whether a person can decide on her own or not. The CRPD's, the committee's position is that whatever you call it, a system that substitutes or that takes away a decision from the individual and puts it or confers it to another person, that system is not in line with the convention. Irrespective of what the mental capacity is, what the CRPD requires is support measures that enable the person to take responsible decisions for himself or herself. And with in this connection, terminology was mentioned. I think in two different ways. Paul, I think you refer to terminology as we usher in new terminology and the courts are interpreting it as if it were the old system. And then the next comment, I don't remember by whom it was, it just turned it around and said, well, we can still use the old terminology. I think terminology matters. If you have a terminology, and particularly in civil law, that is, whose terminology is usually quite the result of very conscious decisions. and discussions. I think terminology matters, and we should not use terminology that were developed under a very different type of thinking for a new type of thinking. It was mentioned that we need to look at the realities. I mean, we as lawyers are in the profession to try to regulate social occurrences, social interactions. And the first thing we need to do is look at, get an understanding of what the social interactions are, of what the issues are. And that's why in the committee we are having so many conversations with persons with disabilities and their representative organizations in order to get a more profound knowledge of what the specific issues of real people are, because that's what the law is designed to govern. So I could only support that comment. Overall, listening to your discussion, I am not quite certain that there was a red thread in it. It meandered quite substantially. I would hope that the idea of the CRPD, that the current laws in place that take away the decision authority from a person and confers it to somebody else, whatever you call it, is something we need to get rid of. And this is why I think the term paradigm change for once, we use it a bit inflationary, but for once is probably an appropriate and an apt description of what's happening here. Thank you.
Thank you very much for this reflection that wraps up our discussion very well. We have to close this session now. I want to thank the three speakers from each of their expertise shared their thoughts on these important concepts. I very much thank the audience for participating in the discussion. It was an interesting discussion, and thank you, Dr. Schaefer, for the, well, somewhat concluding remarks of this session. Krista, you want the floor, please go ahead.
Yes, well, I just wanted to thank you for one. Thank you very much. You ran an excellent session. I thank all of the speakers also. We are exactly on time, which is wonderful. We now will take a lunch break, and I have been asked to make breakout rooms so that you have smaller groups in which you can discuss once you're back from lunch or before you go to lunch or whatever you want to do. So I will go ahead and set up automatic breakout group rooms. You will be arbitrarily assigned to a room, and I will end it in 1 hour so that you still have 15 minutes with everybody together, because maybe you're not in the room with exactly the person you want to talk to. We will resume then at 2 o'clock with our session on the European-wide view of experiences and instruments. I wish you all a very good break, and thank you again. I look forward to seeing you back in 1 hour and 15 minutes. Thank you.